All rise.
The Kosovo Specialist Chambers is now in session. Please be seated.
Good morning and welcome everyone in and outside the courtroom. Mr. Court Officer, could you please call the case?
Good morning, Your Honours. This is file number KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Gucati&Haradinaj.
Thank you, Mr. Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Thank you, Your Honor. For the Specialist Prosecutor's Office appear today Jack Smith, Specialist Prosecutor, Matt Halling, Associate Prosecutor, James Patz, Associate Prosecutor, Artemis Adzistavru, Associate Disclosure Officer, and I am Valeria Bolici, Prosecutor with the SPO.
Thank you, Madam Prosecutor. Now let me turn to the defense, starting with Mr. Rees, please.
Your Honour, my name is Jonathan Rees. I appear on behalf of Mr. Gucati, and we are here on block today with Mr. Hugh Bowden and Miss Eleanor Stevenson.
Thank you, Mr. Rees. And now I turn to Mr. Cadman, please. I see that
Good morning, Your Honour.
it's also
Toby
unblocked
Cadman.
but remotely. Please, Mr. Cadman.
Good morning, Your Honour. Toby Cadman for Mr. Nassim Haradinaj, joined by Mr. Carl Buckley and Miss Miriam Botsberg.
Thank you very much, Mr. Cadman. And now I turn to the registry. Mr. Roche, please.
Thank you, Your Honour. Ralph Roach, Judicial Services Division.
Thank you, Mr. Roche. And for the record, I'm Nicholas Guillou, pre-trial judge for this case. On 20 of May, I scheduled the 5th status conference for this case. My goal today is to review the status of the case and to organize exchanges between the parties, as usual, to ensure an expeditious preparation for trial. In particular, I want to discuss disclosure, agreements on points of law and facts, the status of defense investigations, and the accused's access to documents in the detention facilities of the Kosovo Specialist Chambers. I thank the SPO, the defense, and the registry for their written submissions. And as usual, there is no need to repeat your submissions in detail, but I will invite the parties to respond to each other's written submissions in a concise fashion, following each item in the agenda. As usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. Before we discuss about disclosure issues, I would like to start our hearing today with the last topic on our agenda, which is detention issues, a topic that we discussed during the last status conference. I would like to hear from the registry and the parties about the accused access to documents and their interaction with counsel in the detention facilities. In her submissions, the registrar recalled that a secure electronic data sharing system, or SEDS, now operates effectively, and its storage capacity has been extended to 100 gigabytes per user. The registrar is also evaluating the possibility to allow folders to be moved by the parties from legal workflow to the SEDS directly, as requested by the defense during the last status conference, to facilitate their communication with the accused. I would like to thank the registry for all the efforts to facilitate the work of counsel in the context of the COVID-19 pandemic. However, according to the defense, the ongoing practical difficulties in securing adequate facilities for preparation of the defense is still a source of significant frustration because, first, the defense would prefer to use USB hard drive to exchange information with the accused in the detention facilities. And second, because communication between counsel and accused are still made difficult by the fact that they remain separated by a glass window with communication occurring through a telephone line only. In this regard, I also note the submissions of the Haradinaj defense in F196. I also note that the Haradinaj defense indicated that the issue of translations remained an ongoing concern that will affect the ability to be trial-ready as planned. I will therefore invite the registry to provide details on these matters, notably if new medical guidelines are foreseen given the evolution of the COVID-19 pandemic and the vaccination campaign. I invite the registry to indicate if it is possible to explore least restrictive solutions for meetings between the accused and their counsels given the evolution of the pandemic, or if it is still too early given the current health situation. And finally, I would also like the registry to explore with the medical officer the possibility to adapt the guidelines in the future if accused and counsel are both fully vaccinated. Let me first give the floor to the registry. Mr. Roche, please.
Thank you very much, Your Honour. I will seek to address the issues that you've raised one by one. In terms of access to documents, as you have noted, the SEDS system is operating effectively, and that is, to clarify, a system by which detainees can access documents in a computer, an individual computer in their cells. So that does not give them direct access to documents during any face-to-face legal consultations with their counsel. In terms of access to documents during such legal consultations in the detention facility, we have agreed, based on representations from Mr. Rees, and we have provided him with a bespoke laptop and placed some screens in the consultation room so that he and his client may look at documents simultaneously in real time. And obviously, if counsel for Mr. Haradinaj wished for such a solution, we would be able to implement that at very short notice as well. In terms of interaction between counsel and clients, the restrictions in place at the detention facilities are solely and wholly guided by the need to protect all people who attend the detention facilities and also the accused from the pandemic. It is based on independent professional medical advice provided by the medical officer of the Dutch prison service, who provides advice to ourselves and also the other international tribunals who have detainees at the international unit of the prison in Den Haag. This is kept under constant review. This is a dynamic process where, based on the evolution of the pandemic, as Your Honour has described it, the restrictions are reviewed on a constant basis, and it is very much the desired end goal of the registry and the medical officer that the existing necessary restrictions can be removed when the pandemic conditions allow for that to be done. In terms of vaccinations, the final second vaccination of detainees is scheduled for the 4th of June, and that is obviously an important factor, but not the decisive one, because there are also persons such as detention officers, staff and other visitors to the complex, and we need to also consider the potential impact upon them of the potential of catching the virus and becoming infected. So I can say in conclusion that this is a matter that we appreciate the importance of, and it is one that we are engaging on with the medical officer on a very frequent and intensive basis, and as soon as the restrictions can be lifted, that will be done. If Your Honour wishes, I can continue and talk about the folders from legal workflow to the SEDS system and also translations.
Absolutely. Please proceed, Mr. Roche.
Thank you, Your Honour. As regards the transfer en bloc of folders from legal workflow to the SEDS system, that is a matter that is ongoing. There are technical issues. It is sadly beyond my technical knowledge to explain to the court in detail exactly what is involved, but the relevant services of the registry are working on this. It will take some time, but it is being treated as a priority against the other priorities for the maintenance and improvement of the legal workflow system. As regards USB sticks, this and their carriage into the detention facilities, it is not possible to bring USB sticks, but we have found a mitigation, which I explained briefly earlier, in terms of a bespoke laptop, which provides the same functionality in terms of access to documents during legal consultations. And the SEDS system is the safest and most secure method of the regular exchange of documents between counsel and their clients. A USB stick is ultimately a method of carriage of data, and the SEDS system is a more secure method of achieving the same objective. As regards translations, the previous indications of when they would be ready have been adhered to, and the remaining translations beyond those which are legally required to be provided to the defence will be provided to the defence by no later than 15th June, as previously indicated. And the Rule 86.3b outline has also been distributed on, it was completed on the 15th of May and distributed on the 18th of May, as was previously undertaken. So I think that addresses the issues raised by Your Honour, but I would like to conclude by saying that we understand the importance of allowing the need to remove the restrictions currently in place at the detention facilities, and as stated, this is something we are treating with the utmost seriousness and continue to engage on a daily basis with the medical officer. Thank you, Your Honour.
Thank you very much, Mr. Roche, for these detailed submissions. Now I turn to the defense. Mr. Rees, please.
Well, we're very grateful to the assistance of the registry, the Defence Office and the IT team, who this week have engaged in a number of conversations with the Gucati team to try and find workable solutions to allow the conferences that were scheduled for this week to take place and to take place meaningfully. The solution of the provision of a special laptop is very welcome. That's of real assistance to us. The effectiveness of that solution will be enhanced when, hopefully, the capability to copy folders of material rather than individual files from the legal workflow system onto the hard drive, because the hard drive on the laptop will be the tool with which one can take the case documentation into the detention facilities for conferences. The erection of screens in the conference area in the detention unit hasn't yet happened. It is planned to take place this afternoon. Ms. Stevenson will go to assist from the defence's perspective in the installation of those screens to make sure that that is a workable solution while counsel and detainee remain separated by the glass partition. The only other thing that I would wish to add then is this. It's in relation to the relaxation in due course of the restriction, which currently physically separates counsel from detainee, and also family visits to the detainee within the detention unit. It does seem to us, we're grateful for the indication of the target date of the 4th of June to complete the inoculation programme within the detention unit. We had understood, in fact, from the management at the detention unit that all staff and detainees had, in fact, already been fully inoculated. But obviously, we take Mr. Roche's word for that, and we're grateful that if they haven't been fully inoculated, they will be by the 4th of June. We would, whilst acknowledging that, of course, unexpected events can happen, we would nevertheless invite the court to set a target date for the detention unit to lift that physical restriction in place between counsel and detainee, and also to allow family visits to the detention unit. It does seem to us reasonable that when all relevant parties are fully inoculated, that those restrictions are lifted. And setting a target date at this stage, albeit, of course, it can be reviewed in due course if things take a turn for the worse, but setting a target date will be of significant comfort to those within detention and also to their families, to allow them to start looking ahead and planning for those visits in due course. That will be our request at this stage.
Thank you, Mr. Rees. Now I turn to Mr. Cadman, please.
Thank you, Your Honour. Let me also express my gratitude to the registry, Mr. Roche, for addressing some of the issues that we have raised. It is regrettable that it has taken, unfortunately, so long for these matters to be taken seriously and to be properly addressed. I share Mr. Rees's comments that during my last visit with Mr. Haradinaj, it was my understanding that he had certainly received both vaccines, and so had the majority of the detainees. The problem was with the prison guards, and as we had been informed previously, that may not be completed until July, which obviously means that many of these restrictions are not going to be lifted until July, and Your Honour, that is unacceptable. We have previously been told by the registry about the medical advice. We have requested sight of that medical advice so that we can determine whether it's necessary and proportionate, and potentially a challenge can be made. We have been told that it's not a written advice, it's just part of a regular meeting with the registrar. We reiterate our request to actually have sight of that so that we can determine whether that should in fact be challenged. That being said, if the full restrictions are not going to be lifted until July, that of course creates very serious problems with Your Honour being able to transfer this to a trial panel at the end of June. That seems to be highly unlikely as things currently stand. The issue with legal workflow, with the registrar's submission saying that this is working operational and to a satisfactory level, Your Honour, it is not. It is a very difficult system to work with. We of course recognise having the files transferred, being able to be directly transferred from legal workflow to SEDS will be a welcome addition. But as we've heard from Mr. Roche, that is not complete. We don't know when it will be complete. There are of course technical issues with that. There has to be a system put in place where all of these matters are given proper consideration. Close the door. The SEDS system has of course improved matters, and we're grateful to the registry for increasing that to 100 gigabytes. That almost certainly will have to be reviewed now with the additional material that's been served that we will get to when we discuss the massive disclosure. But the SEDS system and the changes to legal workflow are not a replacement for being able to sit with our clients, go through the material. Again, I'm hearing today for the first time that the laptops and screens being used, and of course that will improve matters, but again, I will visit Mr. Haradinaj on Monday and be able to see for myself whether that is an adequate response. But there does continue to be barriers. Concerning the question of the USB sticks, it is wholly illogical if a CD-ROM can be taken into the detention unit and a USB-C stick cannot. I don't see the rationale in that. I will get to the other matter subject to Your Honour's recent ruling in relation to video footage that we are now finally being given access to, albeit not being able to take copies of. I will deal with that when we deal with the question of disclosure. But these are matters that in ordinary proceedings, we would be able to sit down with our clients, go through, analyse that material together, to take proper instructions. We're not able to do that. I will obviously see what improvements have been made on Monday when I see Mr. Haradinaj. But to be honest, Your Honour, at this current stage, I'm sceptical that proper measures are being put in place to enable us to properly prepare for trial. And finally, the question of translation, there has, of course, been some back and forth. We are grateful to the registry for fast-tracking the translation of the pre-trial brief. But of course, that's not the only document that needs to be required. We have to remind ourselves, Your Honour, that this is not an international tribunal. This is an institution of the Republic of Kosovo. The individuals who are on trial are individuals, are citizens of the Republic of Kosovo, and their language is Kosovo-Albanian. They do not speak English. They have a right for that material to be translated. Now, the points that have been made previously, that there is only a legal obligation to translate certain material. That would certainly be the case if a foreign national was being tried in a foreign state. This is not the situation here. This is a citizen of the Republic of Kosovo being tried before an institution of the Republic of Kosovo. And so all material, all relevant material has to be translated, and that is our position.
Thank you very much, Mr. Kedman. I will give the floor to Mr. Roche to reply to the defense teams, if Mr. Roche, if you have anything to add. And I would also like you to clarify, if possible, if the date of June the 4th for the vaccination, does it concern the accused only, or does it also concern the detention unit staff? And for the benefit of the Defense Council who are not based in Netherlands, the Kingdom of the Netherlands applies a rule for the distribution of the vaccine that is practically only based on the age. And this is mainly the reason why there are still a lot of people who are not vaccinated, even if they are in specific working environment. Mr. Roche, please.
Thank you, Your Honour. As regards the operation of the SEDS system, Council is free at any time to engage with the Defence Office, or the Defence Office is the best conduit, and we will endeavour to address any issues. I mean, any technical system involving remote access by a person not physically present in The Hague is going to involve some technical limitations, not least bandwidth, etc. But we have done and will continue to do absolutely everything we can to address the various concerns that have been addressed by Council. As regards the date for vaccinations, unfortunately I don't have the exact date for the finalisation of vaccination for the detention officers. It is soon. It is after the 4th of June, but not significantly. A number of detainees have already received the second inoculation. Obviously, I won't go into the specifics of who, but the final second vaccination for detainees will be completed by the 4th of June, with that for the detention officers soon afterwards. But again, I would point out that that is not the sole criterion in this issue. There are a range of other factors which do need to be taken into account. But at the risk of repeating myself, this is something we understand the importance and the urgency of. Thank you, Your Honour.
Thank you very much, Mr. Roche. I take note of the request from the Gucati defense team to issue a target date for the restrictions to be lifted. As I am today, I am not in a position to determine this target date because I haven't seen any medical advice from the medical officer. But I would strongly advise the registry to consult with the medical officer and to issue either a target date or guidelines that will explain when and under which condition the measures will be lifted. Because I think, as Mr. Roche said, this is a dynamic process. There is no question that this is not here to stay. This is linked with the current health situation. And there has to be clear parameters that need to be taken into consideration to be able to decide on the restrictions to be lifted. Mr. Kedman, I see that you requested the floor. Please.
Your Honour, as I had mentioned earlier, we have not seen the medical advice. I now hear for the first time that Your Honour has not seen the medical advice. Clearly, you need to see the medical advice so that you can make a determination of proportionality and necessity. It is with concern that you are not being provided with that. That was the only point I wanted to raise.
Thank you, Mr. Cadman. Mr. Rees, do you have anything to add?
No, I echo Mr. Cadman's observation.
Thank you, Mr. Rees. Mr. Roche, anything else to add?
Thank you, Your Honour. Just a final word that the approach of the registry is to advocate for lifting of restrictions. We are not, for example, passively listening to the advice and accepting it. Our approach is to say that we would want the restrictions to be lifted as soon as they can responsibly be lifted, and we will continue to advocate for such an approach. Thank you.
So I think that we all have the same objective. Now it's a question of working closely with the medical officer so restrictions can be lifted as soon as possible. And in any case, we will monitor the vaccination campaign so that this be implemented as soon as possible. I don't see anybody requesting the floor on this issue, so we will move now to the first item in our agenda. I would like now to hear from the parties on the disclosure of evidentiary material. We will start with the issue of the recent SPO request for non-disclosure, which will be discussed in private session. We will then move back to public session to discuss the other matters related to disclosure and the remainder of the agenda. Mr. Court Officer, can we please move into private session?
We are in public session, Your Honours.
Thank you, Mr. Court Officer. So let us now move to the reminder of the disclosure process. I first note that the SPO does not foresee any difficulties related to the remainder of the disclosure process. However, the SPO indicated that on 7 May 2021, it received a partial response to a third-party request and that the relevant material was disclosed on 25 May 2021. Accordingly, the third-party request remains partly outstanding, and any material subsequently received will also be disclosed pursuant to the applicable legal framework. In their submissions, the defense reiterated their concern expressed previously regarding continuing disclosure difficulties. So I would like to hear from the parties whether they foresee any other difficulties related to the remainder of the disclosure process. And I also note that the defense for Mr. Gucati foresees to be able to submit objections to admissibility by 14th June, while the defense for Mr. Haradinaj submits that this is not possible. So I invite the defense to make any further submissions on this point as well. Let me first give the floor to the prosecution, Madam Prosecutor.
Thank you, Your Honor. So first, we welcome the Gucati defense commitment to indicate their objections to admissibility of evidence by the 14th of June, although we know that the Council indicated that details supporting such objections would only be provided after that. It is not indicated how long thereafter, and we simply submit respectfully that the mere assertion that the admissibility of an item is objected to is of little use for both the court and the parties if the reasons underlying those objections are not clarified. So we would encourage the defense to highlight such reasons rather than providing the mere list of the items being objected. In relation to the submissions from the Haradinaj defense, I note that the Council makes a general allegation that this will not be possible because the materials, the relevant materials, has not been disclosed in time. The SPO has responded on a number of occasions, recently in written submission on such allegation, confirming that they are wholly ungrounded. In particular, I will refrain from recalling once again on this occasion the SPO's compliance with the timetable set by the court, and the procedural history of this case speaks for itself. I'll just note, however, that the exhibit list has been filed on the 9th of April, according to the consolidated calendar, and that there has been a single authorized addition since for good cause. Furthermore, as previously highlighted, the bulk of the evidence in the exhibit list was already part of the indictment supporting materials in possession of the defense since early January. We submit, therefore, that there's been ample time to assess admissibility issues, if any. In relation to the 25th of May disclosure, I note that the defense emphasized the number of pages of this disclosure of the materials recently received by this third party. First, I would like to recall that this disclosure has not come unexpectedly, as instead submitted by the defense. The SPO had previously provided notice in at least 3 different status conferences that there was one outstanding third-party request and that relevant material would be disclosed as soon as received. I also wish to underline that the nature of this material is not a collection of statements, is not a narrative that needs to be assessed line by line. These are metadata, the printout of a database, and mostly string of numbers that should be treated as such. So the impact that the defense alleged this disclosure to have on their preparation cannot certainly be measured in terms of number of pages. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Rees, please.
Your Honour, the position of the SPO is frankly becoming mendacious. I will go through the history. At the first status conference, a deadline of the 19th of February 2021 was set at the request of the prosecution for them to complete disclosure of all Rule 102.1, Rule 102.3 and 103 material. They stated at that first status conference that they did not expect large volumes of Rule 102 material to be disclosed. At the second status conference on the 24th of February 2021, they told Your Honour that on the 19th of February the prosecution had discharged all of its obligations under Rule 102.1b. By that stage, some 3,000 pages of evidence had been disclosed. The defence asked at that stage, because although not great in volume, 3,000 pages, it was detailed transcript evidence with many hours of video footage. And there were outstanding significant defence investigations that we predicted we would require to undertake. We asked for the 2nd of July 2021 as the deadline to file the defence pretrial brief that we told Your Honour we intended to, and we still intend, to file. Following that second status conference, Your Honour issued the consolidated calendar, which brought forward a defence proposal to file a defence pretrial brief by 15 working days to the 14th of June. That was, of course, on the basis, as the SPO told Your Honour, unequivocally, that all Rule 102.1 material had been disclosed. At the third status conference, the prosecution did refer to 2 outstanding requests to third parties. They gave no indication as to who those third parties were or what type of material it was or the amount of material that was to be expected. Nor did they even say to Your Honour, to give Your Honour the assistance of saying, well, we don't know how much material this might produce. What they did state to you, Your Honour, at paragraph 8 of their written submissions, was that the bulk of the SPO's disclosure had been completed on the 19th of February 2021. And extraordinarily, that phrase is repeated today. I'm not sure in what sense the word bulk is understood. It's clearly not a mathematical sense, or indeed any sense as normally understood. Because the obvious impression that was being painted for Your Honour and the parties was that whatever was outstanding from these 2 additional third-party requests would not be of any great volume. And indeed, reinforcing that impression, they assured Your Honour that any further material that might come would be disclosed by the 9th of April 2021. The 9th of April 2021 came and went. Your Honour will recall from the last status conference that on effectively the eve of it, 1 full working day before the 28th of April, there were a series of further disclosures made to the defence. These were made under Rule 102.3, despite the fact that Your Honour had ordered all Rule 102.3 material to be disclosed by the 19th of February 2021. And I won't go through the history, lamentable as it is, of the Rule 102.3 notice, because Your Honour will know it, and know it well. But Your Honour might also recall at the fourth status conference, we said, well, we had these disclosures, they'd been made on the eve of the status conference. We were busy responding to Your Honour's order for the fourth status conference, preparing detailed written submissions for the hearing itself. So we weren't in a position to assist with the material that had been dropped on us. Well, I can now, because that material ought to have been made by the 19th of February. 19th of February came and went, Your Honour being assured by the prosecution that all obligations had been met by the 19th of February. All Rule 102.3 material, there wasn't going to be much of volume, had already been disclosed. That material was 17 lever arch files of material. At the fourth status conference, while we had yet to assess the material that had been dropped on us, effectively on the eve of it. Your Honour may recall that both myself and Mr. Cadman asked for some consideration to be given before similar late disclosures are made on the eve of status conferences. The prosecution assured the court that Rule 102.1 material, Rule 102.1 disclosure was complete. They did say that there was a single further request envisaged to add to the exhibit list. That related to the declaration of witness 04841, her declaration on the 14th of April 2021, which had been disclosed by that stage. So we had a copy of that declaration. Your Honour may recall the SPO indicated specifically that there was one further request they envisaged to add to the exhibit list that related to that declaration. So despite their assertion, again, to Your Honour, at the fourth status conference, only one further addition to the exhibit list envisaged, despite us requesting, not unreasonably, that the SPO try and avoid making voluminous disclosures on the eve of status conferences, despite the fact that they knew when we said to Your Honour that we'd had disclosures on the 28th of April, but we hadn't had time to ascertain what was in there. They knew, without telling Your Honour or saying anything to Your Honour, that that included a very significant volume of Rule 102.3 material, 17 lever arch files worth. They said nothing to Your Honour about that or the parties to assist on the last status conference. On the eve of this status conference, they double up on that trick. And despite having had the material earlier in May, they disclosed some 18,549 pages. And the Rule 102.1. And despite assuring Your Honour that they only envisaged one further request to add to the exhibit list, that was in relation to the 14th of April declaration of W04841 on the last status conference, they disclosed those 18,554 pages, saying they intended to add that to the exhibit list via a request to come. And they also said that, in fact, there's more material on its way. although, and this is very much part of the pattern, they give no assistance, and they give no assistance to Your Honour either, as to what that material is, how much it might be. They do try and give Your Honour another assurance, yet another assurance, that 18,549 page bundle that they seek to add to their exhibit list is of no great significance, they say. Well, Your Honour will forgive me if I reserve my judgment on the significance or otherwise of that material, as a good lawyer should do, until I have read it, and I've analysed it, and I've taken instructions upon it. And I cannot do that in relation to 18,549 pages of complex, highly technical evidence quickly, and I cannot rush and jump to, and I do not make any assurances to Your Honour in those circumstances of the significance of that material or otherwise. There have been repeated assurances that have been made to Your Honour throughout these proceedings, relatively young as they are, although the time is growing, repeated assurances from the SPO that have turned out to be wrong and misleading. And I've expressed scepticism at the last status conference and the conference before that, and my scepticism continues not to be comforted, but it only grows. We, of course, still have to deal with the 17 Livre Arch files of material that was disclosed on the eve of the last status conference. To add to those 17 Livre Arch files, we have 18,500 additional pages dropped on us on the eve of this status conference that we now have to read, analyse, take instructions upon, assimilate. And we await, we are told, further material without any assistance as to what it is or the volume that might come, or even the candid acknowledgement from the SPO that they don't know, if that is the case, how much further material there is still to come that they will seek to add to their exhibit list. It is time for the SPO to realise that they should be candid with the court about these matters. We know there is further disclosure to come because Your Honour has ordered it. One aspect of Your Honour's order, rejecting the SPO's request to withhold material, related to search videos. At the time at which the SPO addressed Your Honour, in writing and orally, about those search videos, Your Honour was told, and indeed at the time Your Honour ruled on it, Your Honour was told that in fact, although there were 11 videos noted on the Rule 1023 notice, they were duplicates. So there was in fact only 2 videos, 2 separate videos, one of which had been duplicated 10 times, I think. Well, in fact, that's not right, because following Your Honour's order to give access to those videos, arrangements were made to view them, and we were told that, in fact, a further 8 videos had been discovered. Now, of course, they have been made available to us consequent to Your Honour's order. But it does cause, again, further concern as to whether the SPO are properly carrying out their obligations to, inter alia, list all relevant material that they have in their possession on the Rule 1023 notice. These 8 videos were not. Why were they not discovered before yesterday? Why were they not on the Rule 1023 notice? Had any attempt properly been made to identify all relevant material in Mr. Smith's possession to then put on a detailed notice that is complete, comprehensive, and with sufficient information for the defence to be able to properly make submissions as to whether any item on that list is material to the defence preparation? There is to be, it follows, further additions to the Rule 1023 notice. Or at least, if the SPO are serious about complying with their disclosure obligations, there is to be a further version of the Rule 1023 notice. The fact of a further version follows from Your Honour's orders to make disclosure. For example, Your Honour has made orders to make disclosure in relation to what was described as Gucati Request A. Gucati Request A related to material that was absent from the Rule 1023 notice, that the SPO were forced to provide after a dispute as to the adequacy of what we termed the paltry 13-item Rule 1023 notice, which Your Honour ruled upon. And as a result of Your Honour's ruling, expanded from 13 items to over, I think, approximately, well over 100. I think it was approximately 150. None of the material that Your Honour has ordered to be reviewed for disclosure purposes under Gucati Request A and to make disclosure as per Your Honour's order appears on that Rule 1023 notice. And it ought to have done. And obviously where a document is disclosed, that does not require recording on the Rule 1023 notice. Any contemporaneous note that is reviewed in accordance with Your Honour's order and disclosure does not take place, that will by necessity require an addendum to the Rule 1023 notice in relation to that material. In relation to any further Rule 1021B material that we are given notice of by way of email informing us of the material that was disclosed recently and turned out to be some 18,500 pages, we ask Your Honour to order a deadline for service of any material that the SPO intends to serve under Rule 1021B, together with a deadline for any further application to add to the exhibit list. And we invite Your Honour to set a short timetable, a short deadline, to reflect the court's requirement that the time has come for the SPO's repeated assurances that their case is complete. Time has come for those assurances finally to be made good. We have said we've said previously, we indicated at the last status conference that we intended to meet the 14th of June direction in relation to the pre-trial brief. And we said at that status conference that we intended to meet at the same time to identify objections to admissibility at the same time. In our written submissions, we express that we will not be ready for the 14th of June to serve the defence pre-trial brief. We cannot be. In light of the way in which the SPO has handled their disclosure obligations, making repeated assurances everything's complete, and then surprise after surprise. In particular, within the last month, some 17 Leverage files and 18,500 additional pages being provided to us. So we do ask the court to lift the deadline for the defence to voluntarily file, and we do intend to voluntarily file a defence pre-trial brief from its current date of the 14th of June. We have set out that in order to assist, we can nevertheless attempt to list the items of evidence on the exhibit list as it currently stands that we intend to object to their admissibility. That list, I can say here and now, will be many times longer than the paltry 13-item original Rule 1023 list. It will be a work in itself of some length, and it will be time-consuming. And I am content that in that list we can have a column where effectively in a word or two we can identify the general nature of the objection. So, for example, hearsay. But we certainly will not be in a position to draft motions, detailed submissions, as to the objection on grounds of admissibility to the evidence that we intend to object to. We have yet to wrestle with 17 Leverage files and 18,500 pages of highly complex technical evidence that have been landed upon us in the course of the last month. So we do, in a spirit of trying to give assistance, as we have said in our written submissions, we will aim to produce, as far as we're able to, a list of such exhibits that we presently intend to object to, and if necessary, identify by a word or two an objection, hearsay, etc. And if it is understood on that basis, then Your Honour can make that a target date. In relation to when the defence pre-trial brief itself may be ready, it is difficult for me at this stage, because of the state of flux in which this case presently is now in, to meaningfully set out a proposed timetable. Not only do we have the matters that I've already raised to deal with, not only do we have the suggestion that there is further material to come under Rule 1021B, but without any assistance as to how much or what it is. Not only do we have the further disclosure that Your Honour has ordered to the SPO to make, that is to come. Not only do we have the issue in relation to items 99 and so on, which Your Honour will understand the material I refer to. Not only do we have that material and the resolution, at least provisionally, to come, we also, of course, still have an outstanding appeal to the Court of Appeals panel, with Your Honour's leave, in relation to the scope of the indictment. The consequences of that decision, until we receive it, we cannot say. But Your Honour will readily see that there may be consequences that flow in terms of the defence preparation from that decision, one way or the other. But perhaps aiming to be of assistance, but encouraging the court to at least set this down provisionally, but with some understanding if in due course these targets are not met. The current date of the 14th of June might serve, Your Honour, as a proper deadline for the SPO to deal with all outstanding matters and assure the court that's it. And if they met that, and all other outstanding issues are resolved by the 14th of June, 28 days after that would be the 12th of July. And we will, of course, continue to work on such matters as we're able to at this stage in the interim, with a view on best case scenario of being able to file our voluntary defence pretrial brief on the 12th of July. I think it is the case in relation to each of the parties that it's proposed that there be a further status conference after service of any pretrial brief and before the transmission of a case file to the trial panel, and perhaps 2 weeks after that date would be the Monday the 26th of July, before the holiday period, of course, for the holiday recess. So perhaps the 26th of July might be a convenient date on that timetable for a further status conference. And of course, at that stage, we can look to see whether, in fact, the SPO has been able to resolve all outstanding matters accordingly. Unless I can assist any further on these matters, Your Honour.
Thank you very much, Mr. Rees. I see that it's already 2 hours, so we have 20 seconds.
Just very quickly, Ms. Stevenson has to go as well at 1 o'clock, but I think Your Honour was just about to refer to a short recess, perhaps.
Absolutely. I apologize for the interpreters. I didn't expect that you were going to be that long, Mr. Rees, so I thought we would be able to break earlier. So I apologize to the interpreters. We're going to make a break of 20 minutes, and we'll be back in the courtroom in 20 minutes for the remainder of this hearing. The hearing is adjourned.
All rise. All rise.
Please be seated.
Welcome back. We will continue with the issue of disclosure with Mr. Cadman. Just before we continue, Mr. Cadman, just to inform you that the other defense team has a flight to catch. So if you could be maybe not brief, but at least not too long, I think they would appreciate. If not, they will be stuck in the Netherlands for the next 20 days, which is something they might not appreciate. Please proceed, Mr. Cadman.
Your Honour, as my learned friend and his team need to leave early, and as Mr. Rees has very kindly dealt with pretty much every issue that I could have dealt with in such a forceful and eloquent way, I will keep my submissions as brief as I possibly can. Let me start by saying that it is in Mr. Haradinaj's interest that these matters are dealt with expeditiously, and certainly there is no intention to delay these proceedings any further than absolutely necessary, and certainly it is not the position of the defence to extend these proceedings further than absolutely necessary. That said, the remark that was made in our written submissions as to the feasibility of having the pre-trial brief completed by 14th of June is, of course, a matter which is directly relevant to, as Mr. Rees has said, the 17 lever arch files that were served before the last status conference and the 18,000 pages worth of documents that have now been served. And whilst the prosecutor may not consider them to be relevant, as Mr. Rees has said, it is our position that we will need to deal with them in detail. And I've asked Mr. Buckley to deal with that point in particular. But let me, before we get into that, let me just make a few remarks, some of which I've already made. One of the concerns that we have is that there appears to be a recurring theme or a pattern in many of these cases before the specialist chambers that gives us real cause for concern. Arrests are made and indictments are filed long before these cases are ready to proceed. Mr. Haradinaj has been detained for 8 months, and many of the defendants before this court are being detained for unnecessary lengthy periods. We see repeated flagrant disregard for transparency, for fair trial and protection of human rights and fundamental freedoms, and these are of concern. And the defence is repeatedly accused of seeking to delay these proceedings and making unnecessary demands of the prosecution, in particular what investigations the SBO has conducted. And these reasonable requests are dealt with, as I've said before, with responses that can only be described as condescension. And it is an inappropriate way for these proceedings to be managed. As I'd said earlier today, the prosecution seeks to bring a case without disclosing the material against our clients, not only to us, for the defence, Your Honour, but to you as well. We don't have access to scrutinise that material, and the prosecution seeks to rely on witness accounts that we're not even going to be able to cross-examine. As I've said, and without going in the need to go back into closed session, the prosecution is seeking to bring its case entirely on evidence that is covered by anonymity, closed session, and voice and face distortion. That means the entirety of their trial is likely to be conducted in secret. We've repeatedly requested that the court recognise the defence is entitled to disclosure, and we have repeatedly made requests to the prosecution as to the manner in which the documents are said to have been leaked. We do consider that to be a relevant matter, and we're certainly entitled to investigate that. as to a potential defence that can be put. The requests that we have made of the prosecution have been met with, these are matters that are of no relevance, or they're matters relevant to the trial. We have requested whether any action was taken against SBO members who may or may not have been involved in the leaking of such documents. We're entitled to know what investigations have been conducted. We have been forced to investigate those matters ourselves. And that is, of course, extending the time needed for defence investigations. We are aware that a large number of SBO personnel whose contracts were not extended immediately after the leak, that may or may not be related to these proceedings. But again, these are matters that we are entitled to investigate and entitled to know what the prosecution has actually done. We consider it to be the lack of an effective investigation by the SBO central to this case. Now, the prosecution, as I said, will argue that this is irrelevant and it's a trial issue. We do not consider it to be a trial issue. There are real concerns as to chain of custody. There is no statement from the officer who took custody of the material that's said to have been leaked. That is a matter of concern. Now, Your Honour made a ruling a matter of days ago as to the ability for us to review video footage that related to the search and seizure of the material. We have been told that we are only able to observe that material in the SBO premises, in the presence of SBO staff. We are allowed to take notes, but we are not entitled to take possession of that video footage, and we are only able to present our clients with notes. We can't show them the footage so that they can identify who they remember and what they remember to have happened. And Your Honour, this is a damning accusation of specialist counsel before this court. It is not the defence that have held private briefings with members of the diplomatic community and have discussed these matters with parties outside of the court, yet we are being penalised as a result of the so-called confidentiality of these matters, and it is of some concern. Of course, I will have the opportunity to review the material, and we will have an opportunity, if we deem appropriate, to appeal your ruling, and to appeal your ruling in respect of what we consider to be an error of the Gucati requests B and C. Those are matters, as I mentioned, that are critical to the defence preparations, and so we have to be able to investigate those frequently. Your Honour, I make these as general observations that continue to impact upon our ability to move this case forward, properly forward, within the timeline, the time schedule that Your Honour has set. It is going to be very, very difficult to comply with the deadline of effectively 16 or 17 days to deal with the filing of a pretrial brief. Of course, we fully intend to file a pretrial brief. We intend to deal with the question of admissibility of evidence within that. We intend to deal with any agreement that can be made as to the facts of the law, as we have previously discussed with the SPO. We are not in a position to do that at this stage. We hope to be in a position to do that when we file the pretrial brief, but I think it is highly unrealistic to expect us to do that within 16, 17 days when we have 18,000 pages of documents that we do need to consider. I will stop there, Your Honour, as I know others need to leave. I'll just ask Mr. Buckley to deal very briefly with the question of the 18,000 pages.
Thank you, Mr. Kedman. Mr. Buckley, please.
Your Honour, I'm grateful. I also acknowledge the time pressures, and I will be as brief as I possibly can. Your Honour, it's quite clear that what you're hearing this morning is collective frustration on the part of both defence teams in terms of the manner in which this disclosure process has been undertaken by the SVO. The SVO has consistently submitted that it doesn't foresee any issues with the disclosure process going forward, and that is something that it has submitted on previous case status hearings. However, I would respectfully submit that it has become abundantly clear that there are very real difficulties with disclosure going forward, much as there has been previously. Further, the SVO has previously sought to suggest that the defence are seeking to delay this case. Again, that position was as wholly inaccurate then as it is now. And if anything, the position is even more stark this morning than it has been previously. The reality of the matter is what ought to have been a relatively straightforward process has become significantly protracted. And it has been protracted solely down to this drip feed approach to disclosure that we are all still suffering from. Mr. Rees previously outlined how before the Fall Status Conference, a significant amount of further disclosure was made just one day prior to that conference, approximately 17 lever arch files. Using a generalized metric of 500 pages per file, that is approximately 8,500 pages of disclosure. Yet again, before this hearing, again, further disclosure was made, and as Mr. Rees outlined, the SVO doubled up in terms of its page count, and somewhere in the region of 18,500 pages of disclosure, which gives us a total from 2 case status hearings of 26 to 27,000 pages of disclosure. And I make no apology for the strength of my submissions, Your Honour, but such an approach ought not to be tolerated. The SVO has continually sought to suggest at various stages that its disclosure obligations are complete. Clearly, they are not. Further, the SVO have sought to suggest that this case will be ready to be transferred to the trial panel. Again, clearly, it is not. What the SVO have not maintained, however, is that the defendants have an absolute right to a fair trial. And at this stage, that guarantee has not been adhered to. Dealing with the specifics of the most recent disclosure, 18,500 pages need to be read. At the commonly accepted metric of 2 minutes per page, that is 37,000 minutes, 618 hours, or 88 days. Now, I accept that one individual is not necessarily going to read all of it, and the initial assessment may be split across a number of members of the team. However, it is still a significant, massive time commitment. I also note the SVO submission that not all of those pages are relevant. However, the SVO appears to be conflating opinion with fact. It goes on to suggest that they need not be read line by line. My apologies, Your Honour, but that is wholly inaccurate. And again, this is the difference between their opinion and fact. Regardless of whether the SPO deem those pages to be relevant, the defence are required to read every word of every page. Both defence teams have clear professional obligations to their clients, those professional obligations including considering all of the evidence that is disclosed, each and every word of that evidence, regardless of whether the SPO deem it relevant or needed for trial or otherwise. That is not their decision to make. I echo Mr. Rees's points in terms of the procedural history of this case. And again, the fact that there's previous submissions of the SPO are demonstrably inaccurate, and therefore to seek to attach any blame to the defence and infer that it is the defence that is being difficult in this process is wholly disingenuous. This case is not ready to be transferred to the trial panel in our respectful submission, nor will it be whilst there are still significant issues that fall to be addressed, including the anticipated further disclosure of an unknown volume alluded to by the SPO in their most recent submissions. The SPO simply have to be clear on what it is that they have and what it is that they tend to disclose, not just subject matter, but volume. It has to be done so as to ensure that this matter can be progressed expeditiously, something that they are summarily failing to do at this stage. All of these issues directly affect the ability of the defendant to prepare the case, and accordingly directly affect the ability of the defendant's legal team to undertake those necessary preparations, including the drafting of the pre-trial brief. Again, as has already been alluded to, at this stage, the current date for the submission of the pre-trial brief simply cannot be met. If the previous assertions of the SPO had been correct, then that deadline could have and would have been met. Unfortunately, those previous assertions and every assertion since has been incorrect. Again, given the protracted nature of the disclosure process, the ability to submit objections to evidence or otherwise is again delayed. The exhibits list was disclosed on the 9th of April, and that is all well and good, Your Honour. However, the process does not start and end with the disclosure of the exhibits list. It is the disclosure of the evidence itself that also informs the defence case and informs the decision on whether objections is to be raised or otherwise. It is therefore not correct to suggest that everything was available on the 9th of April and therefore the process and timelines could be met, because that is, again, incorrect. I would respectfully ask, Your Honour, that we now be realistic with any timeline that is imposed. We acknowledge our obligation to deal with matters expeditiously and to ensure that this case proceeds as it should. In the same vein, however, the SVO is subject to those same obligations that they have failed to adhere to up to this current date, and thus the defence is precluded from adhering to its obligations, not because it is being difficult, not because it is seeking to delay matters, but it is simply a natural progression of that which has gone before. Your Honour, I could address you at length on those matters, but again, because of time pressures, I conclude my submissions.
Thank you very much, Mr. Buckley. I give back the floor to the SPO, and if you could also tackle the point mentioned by Mr. Rees about the videos,
Yes.
that would be much appreciated.
Yes, thank you, Your Honor. I will address the defense allegations very briefly. I understand that the defense requests an extension of the deadline set for the filing of the pre-trial brief. They can do so by showing good cause. For sure, they cannot do so by misrepresenting the procedural history of this case, which I do not intend to recall, if not by confirming that the SPO complied with its deadlines step by step, requested authorization for each undertaken step, and anticipated any issue both with the parties and with the court. On the last remark from the counsel for Mr. Haradinaj, yes, all the materials that has been indicated on the exhibit list have been, of course, disclosed prior to the filing of the exhibit list, so this is not an issue and can hardly be disputed. I would like instead to go back to the issue of the video concerning the search and seizures. Following your honor orders, we proactively engaged with the Gucati's defense in order to organize the first viewing yesterday. And when the videos were uploaded on the laptop that has been made available to the defense, it became apparent that the 11 items that have been listed on the 1023 notice are actually distinct pieces of footage, distinct videos that do not duplicate each other. Admittedly, there has been an error in the process of uploading the videos in the evidentiary software, so that the same videos has been linked several times to different year ends. All of the 11 videos have been made available to the Gucati defense yesterday, the same conditions as indicated in Your Honor's recent decisions, and we are in the process of disclosing the full package of videos to the court, which we aim to do by today. The defense for Haradinaj has indicated that they will intend to look at the video as well on Monday, which has been arranged already, and the defense for Mr. Gucati indicated that they intend to review the videos again. That will be arranged as soon as the relevant dates will be indicated. That would conclude my submissions for this point. Thank you, Your Honor.
Thank you, Madam Prosecutor. Mr. Rees, do you want to add anything? Mr. Cadman.
Your Honour, just to reiterate, and we can, of course, put it into a written submission, but our position is it is wholly inappropriate for us to review those videos without being able to go through them with our clients, but without being able to take full instructions on those. Of course, that relates to your previous decision, and we will have to take the necessary steps in relation to that. But it is impossible for us to be able to take instructions without being able to take possession of that video footage. And we see no reason why counsel who are members of the Bar of England and Wales, specialist counsel in this court, cannot be trusted to observe those video footage outside the court premises.
Mr. Cadman, I've already ruled on that matter. So either you file a request for reconsideration or you file a request for leave to appeal. These are the two possibilities. I understand what you're saying, but then I invite to choose one of the other if you wish to dispute my ruling.
Which we've already indicated we will, Your Honour.
Thank you, Mr. Cadman. Madam Prosecutor, nothing else? Thank you. We're gonna move to the next item in our agenda, which is the agreement on points of law and fact. I note that the SPO communicated to the defense a proposition on agreed facts on March the 12th. No proposition to agree on points of law has been made. I also note that the Gucati defense estimates that an agreement on points of fact is unlikely, except biographical details, the dates of televised press conferences, and speakers therein. But both defense teams indicated that they will be in a better position to identify any agreement on points of facts in their pretrial brief or after their pretrial brief is filed. So I take note that no agreement will be reached before the defense pretrial brief. Do the parties wish to add anything on this topic? Madam Prosecutor.
Thank you, Your Honor.
Mr. Rees? Do you mind?
No, thank you, Your Honour.
Thank you. It's for the transcript. Mr. Cadman, please.
No, Your Honour.
Thank you, Mr. Cadman. Then we'll move to the next point on our agenda, which is the defense investigations. I invite the defense to provide updates on the status of its investigation, including the estimated overall amount and type of evidence it intends to disclose to the SPO, and whether requests for protective measures are envisaged. I note that the defense do not intend to offer a defense of alibi. I also note that the defense have not finalized its position at this stage regarding grounds excluding responsibility, and therefore cannot comment in the positive or the negative in terms of the defense to be advanced. And finally, I note that no request for unique investigative measures is envisaged. So I invite the defense for the submissions on this matter and to indicate if this also has an impact on their ability to meet the current targets. But I think this has already been addressed in the previous submissions of the defense. So unless you want to add anything related to your investigations, I think we've already discussed that matter. Mr. Rees, please.
No, Your Honour, I have nothing further to add than that which I've set out in the written submission. Thank you.
Thank you, Mr. Rees. Mr. Cadman, please.
I think, Your Honour, I take the same position. Nothing I need to add further.
Thank you, Mr. Cadman. Does the defendant want to say anything about this? The prosecution, sorry.
Sorry. Thank you, Your Honor. Just one clarification about defense submissions on other grounds excluding criminal responsibility pursuant to Rule 95(5), because I recall that in the consolidated calendar, the defense was supposed to submit such information by the 11th of May, but there has been no indication in the latest submission whether they intend or not at all to submit such defenses. So it's just a request of clarification whether any such defense is going to be put forth, or there is a request for extension of this deadline, or the defense is not yet in a position to provide his opinion on that. Thank you.
Thank you, Madam Prosecutor. My impression, and this is what I just mentioned, is that the defense is not in a position to do so despite the previous deadline, given the disclosure issues that have been flagged by the defense earlier. Is that correct, Mr. Rees?
That is correct. I could address, Your Honour, at some length about how the operation of Rule 95 and how there is a distinction between the voluntary invitation to submit a defence pretrial brief, which requires some detail in the sense that there are the requirements of general nature of the defence, and then to respond to the prosecution pretrial brief by paragraph, and the compulsory requirement to give notice of specific defences. In circumstances where we have said from the outset that we intend to take up Your Honour's invitation to submit a voluntary pre-trial brief, our defence will be set out in the pre-trial briefs. There will be no suggestion the SPO will not have notice of our defence.
Thank you, Mr. Rees. Mr. Cadman, do you want to add anything on this?
Only to say, Your Honour, I believe we've set that out in our written submissions already, that any defence as such will be set out in the pre-trial brief.
Thank you, Mr. Cadman. I would now like to hear the parties of their views on a suitable date for the next status conference. Madam Prosecutor.
Your Honor, the SPO would welcome further status conference depending on the deadline that will be indicated by the defense on the submission of the pre-trial brief. It would be meaningful to have status conference after that time. Thank you.
Thank you, Madam Prosecutor. Mr. Rees?
Your Honour, I've already set out my proposal for a timetable looking forward, but accepting that even at this stage there is room for that, those deadlines not to be met for different reasons. And we'll go back over that, but that's my proposal at this stage for Your Honour's assistance. I hope it helps.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, having heard Mr. Rees on his estimation of an appropriate timetable, we would support that.
Thank you, Mr. Cadman. At this point, I'd like to ask the parties whether they wish to raise any other issue. Madam Prosecutor.
Nothing for the SPO, Your Honor. Thank you.
Mr. Rees?
No, thank you, Your Honour.
And Mr. Cadman.
In the interest of time, Your Honour, nothing further.
Thank you very much. Unless the parties have anything to add, this concludes today's hearing. As usual, I thank the stenographer, AV technicians and interpreters for their assistance, and security personnel as well. And we will meet for a further status conference in due course. The hearing is adjourned.
All rise.